Group B, Note 1, Insolvency. The meaning of insolvency and the manner in which a person acquires an insolvent status. A. Bibliography and general remarks. A. Our statute law. Our entire law of insolvency has been consolidated by Act No. 24 of 1936. This is one of the most important Union statutes. For example, it is one of the acts prescribed for the examination which must be passed by a person who has studied at a foreign university before he can be called to the bar. It is a fairly comprehensive act comprising 159 sections. Students must obtain this act and study it thoroughly. This is necessary for various reasons. Students must, for example, become conversant with a mode of expression used by the legislator, and should learn how to read and interpret the statutes. B. Our case law. It is clear that insolvency cases frequently occur in our courts. There are more lean than fat years, and there will always be the unfortunate ones who are unable to make ends meet. Young barristers should, therefore, be conversant with the law of insolvency and the law of divorce, for the saying, "one man's meat is another man's poison," applies here with all force. Divorce and insolvency cases are usually plentiful. Students should also pay attention to the development of our law of insolvency by the courts. Their studies in that direction will be very much facilitated by studying C. Mars, the law of insolvency. This is a standard work on the law of insolvency. The 4th edition is edited by Advocate Hockley of Cape Town. Advocate Mars also practiced in Cape Town. The 4th edition is now available. It comprises more than 700 pages and costs something more than £2. Writer van Schalk's bookstore, Pretoria, for the 4th edition. This work gives a very clear, systematic and logical treatment of the subject. Students should therefore study this work as thoroughly as possible, especially those portions referred to in these notes. We must, however, point out that there are also other works on the law of insolvency, as for example Nathan, Law of Insolvency. But the latter work is out of date, and Mars's book is by far the best. Students, however, must note that references to pages in these notes refer to the 4th edition. De Wet and Yeats also have a chapter on this subject in Contractrecht and Handelsrecht. It is written in their usual clear and concise style, and students will certainly find it useful for reference purposes. Division of the course. The various branches of the law of insolvency will, as far as possible, be divided into groups. Questions like the acquisition of an insolvent status, the effect of insolvency on the status of an individual, etc., will be treated in different groups. Students should therefore expect from 4 to 5 groups in the course, but in any case not more than 5. Our method. In these notes we shall sometimes follow the treatment of the subject in the Act, and sometimes the treatment of Mars. We shall always try to discuss the subject as clearly and logically as possible, and we shall refer students to specific references in the sources of the subject. B. Historical review. A. Mars's exposition on pages 1 to 13. Mars gives a very clear and concise exposition of the history of our law of insolvency. This is actually a question which should be treated of in the history of Roman Dutch law, but for the general orientation of the student, as far as the course is concerned, he should read these pages. If the student does so, he will, for example, appreciate that some of the judgments delivered prior to the introduction of the present Act may serve as a guide even today. He will also appreciate why reference is sometimes made to the general principles of our law when interpreting the Act, since in respect of insolvency we had a common law. B. The periods. When making a study of the history of our law of insolvency, students should pay special attention to these periods. 1. The Roman law. It is perhaps difficult to believe today that a little more than 2,000 years ago, a debtor's creditors enjoyed the option, in the event of his being unable to pay his debts, either of selling him into slavery or cutting his body into pieces, with the additional advantage of incurring no liability in case anyone cut more or less than his just share. Mars, page 1. In spite of this harsh rule in regard to the person of the debtor, the powers of the creditors to execute against the property of the debtor were rather limited. About 1 century BC, the Praetor made provision in this connection by the so-called missio in possessionum. It was a taking possession of the assets of the debtor by his creditors. See further Mars, page 2. This provision was, however, only aimed at the interest of the creditors, that is, it was merely a right of recourse and did not protect the debtor against execution in respect of his person. Later, the procedure of cessio bonorum, a surrender of possessions or estate, was introduced, and it would appear that this privilege could be claimed by the debtor as of right for the protection of his own person. Mars, page 3. The matter may therefore be reviewed from 2 angles. 1. The creditors. They have a right of recourse. They may seize the whole estate of the unfortunate debtor, may sell it, and divide the proceeds among themselves. 2. The debtor. He enjoys a measure of protection, a certain privilege. Students must keep these rules in mind during the course of these notes, since they form the gist of the law of insolvency. The creditors acquire a right of recourse over and above the ordinary execution against property, while the debtor acquires certain privileges under the Act. For example, the Act prevents his assets from being frittered away by wasteful legal proceedings. 2. Roman Dutch law. The Roman cessio bonorum was introduced in Holland, whence it was translated to South Africa. For the purpose of this course, little need be said about this question. Students may consult their course on Roman Dutch law as well as Mars, pages 3 to 5. 3. Pre-Union legislation. In the beginning of the 19th century, the law of insolvency of the Cape was regulated by the common law. Later, however, we find various ordinances in the different provinces. For example, the earliest ordinance in the Cape was passed in 1828. In this connection, students may consult Mars, pages 5 to 6. 4. Union legislation. 1. The Insolvency Act No. 32 of 1916. This Act repealed all provincial legislation and substituted a uniform procedure for the whole of the Union. 2. The Insolvency Amendment Act No. 29 of 1926. A number of far-reaching amendments were introduced by this Act. For the first time it was made fairly difficult for a person to become insolvent and then to declare that all his property belonged to his wife. Section 10. See also Mars, page 7, and subsequent notes on the position of the solvent spouse. 5. The present Act, the Insolvency Act No. 24 of 1936. Students will observe how important the question of insolvency is. Every now and then a new Act is passed to keep this important branch of the law up to date. As it is, the 1936 Act has already been amended by an Amendment Act of 1943. The 4th edition of Mars will, of course, deal with the most recent amendments, but students who read the 3rd edition should be careful. The 1936 Act is very comprehensive. It consolidates all Union legislation and is really the charter of persons who find their accounts somewhat too high. 6. Final remarks. The first chapter of Mars, dealing with the history of the subject, is definitely interesting and students will find it worthwhile to read it. The above remarks will, however, suffice for the purposes of this note, and in the following notes we shall discuss the question of jurisdiction to declare a person insolvent. Group B, Note 2. The meaning of insolvency and how a person acquires an insolvent status. Jurisdiction to declare a person insolvent. Mars, Chapter 2, gives a very clear exposition of this question. As we consider it advisable for students to acquire a general idea of jurisdiction as applied to insolvency beforehand, rather than to study each aspect of the whole subject separately, we shall deal with the question more or less on the same lines as Mars. Students must therefore study Chapter 2 very carefully, with special reference to the few important points mentioned hereunder. A. What court has jurisdiction to declare a person insolvent? Since insolvency influences the status of a person, it would perhaps be undesirable to entrust this power to the magistrate's court, especially in view of the fact that officials of the magistrate's court are civil servants, and, as such, officials of the executive. The considerable independence enjoyed by judges of the Supreme Court ensures a greater measure of confidence in that court. The case is stated by competent advocates. There is no lack of time, in any case not to the same extent as in a magistrate's court. Persons promoted to the bench always have a long and honourable career to their credit, etc. For these reasons the Supreme Court enjoys so much more esteem and confidence. It must be made quite clear to students that we definitely do not wish to cast any reflection on the integrity and capability of officials of the magistrate's court. The idea is merely that there should be no trace of subordination to the executive in the case of persons who have to decide on the status of a citizen. Only the most independent institution of the judicial power, namely the Supreme Court, should decide on a person's status. Such as the magistrate's court cannot pass the death sentence, so also jurisdiction in insolvency is regarded as a function which should preferably be exercised by the Supreme Court. Jurisdiction in insolvency is, therefore, vested in the provincial and local divisions of the Supreme Court. It should, however, be noted that the circuit courts, which are also local divisions, are criminal courts in the first instance, referred to notes on law of procedure, although there is no reason why a circuit court may not exercise this jurisdiction. Actually, it has already been done. See Ex parte Olaf, 1923 NLR. The 1936 Act did not change this position. Nevertheless, Act No. 32 of 1944, the new Magistrates' Court Act, confers jurisdiction on the Magistrates' Court to issue administrative orders. Such an order has been styled a kind of cheap insolvency, but the effect of this order is not the same as that of insolvency proceedings in the Supreme Court, referred to the notes on the law of procedure. Nevertheless, a short comparative discussion of administration orders and insolvency proceedings will always make a good impression on the examiner. In this connection we may briefly note the following questions. 1. Concurrent jurisdiction. Where two courts have concurrent jurisdiction in connection with an insolvent estate, the proper court in which to apply for any relief is that to which the master having custody of the estate records is attached, even though the particular asset in respect of which relief is sought is situated within the limits of the local jurisdiction of the other court. See Mars, page 15, and the case is cited by him. Such concurrent jurisdiction is found in the case of provincial and local divisions, referred to notes on the law of procedure. Thus, if a person requires relief in regard to one or other insolvent estate, he should have recourse to the division of the master in whose possession the records of the estates in question are, In due course we shall return to the meaning of the master. 2. Appeals and reviews. The Supreme Court also has authority to review any action of the master. Any person who feels aggrieved by any action or decision of the master may, by way of appeal or motion to review, have recourse to the division of the Supreme Court to which the master is attached. Pay special attention to this point. The master's actions may only be attacked in his own division and not in another division. See Mars, page 15. Also note that the actions of the master may not be attacked in a magistrate's court. The Supreme Court may also set aside any order issued by itself in respect of an insolvent estate. The court may rescind or vary any order made by it under the provision of this Act, Section 149(2), Mars, page 16. Refer further to Sections 150 and 151 regarding the questions of appeals and reviews. 3. Authority for the exercise of discretion in the case of formal defects. Where the Act provides expressly or by implication that this or that must be done, the court must of course reject all proceedings not complying with the Act. But it may happen that one or other omission which is not actually incompatible with the aim of the Act has occurred in connection with the proceedings. This would be a defect, but it is only a formal defect and not an essential one. In such a case, the court may exercise its discretion to condone the defect or irregularity. It must be noted that a merely formal defect will not invalidate any proceedings in insolvency unless the court is of opinion that such substantial injustice has been done that it cannot be remedied by any order it can make. In deciding whether a defect is formal, the test is not whether the provisions of the statute are directly or peremptory, but rather whether the status aims at some definite object, and whether that object would be defeated by an omission to comply with the statute. A defect is not formal if the rights of a creditor would in any way be affected. Mars, page 16. 4. Magistrates' courts also have a jurisdiction in certain cases which follow upon insolvency proceedings. For example, to try a person who has committed an offence in terms of the Act. The question will be fully discussed at a later stage. B. Which estate may be declared insolvent by the courts. We must first note the general principles of jurisdiction over persons and estates. 1. The statute. Section 149(1) treats of this question. Students should read it very carefully and note 2. Mars's exposition. The effect is that there are 4 grounds for the court's jurisdiction, each of which by itself will suffice to found jurisdiction. 1. The debtor must, at the date the petition for sequestration is lodged, either own or be entitled to property within the jurisdiction of the court, or 2. The debtor must be domiciled within the jurisdiction of the court at the time the petition is lodged, or 3. The debtor must be residing within the jurisdiction at the date of lodging of the petition, or, if not actually so residing at such date, must have ordinarily resided therein within 12 months immediately preceding the presentation of the petition, or 4. The debtor must be carrying on business within the jurisdiction at the date of lodging of the petition, or must, at any time within 12 months immediately preceding the lodging of the petition, have carried on business therein. 3. Remarks. 1. Place where act of insolvency is committed. As Mars, page 22, rightly points out, the mere fact that an act of insolvency, we shall deal with this term at a later stage, has been committed within the jurisdiction does not confer jurisdiction on the court. Jurisdiction in insolvency proceedings is based exclusively on the above-mentioned grounds. 2. Territorial principle. The four grounds of jurisdiction reveal a territorial principle. That is, the debtor must be present within the jurisdiction of the court, either personally resident, or as owner or claimant of property, or as a businessman carrying on a business. 3. Domicilium. This means that a person is resident in a place, or, in other words, that he is present in a place with the intention to stay there. In this connection, students should consult their notes on Roman Dutch law. 4. Resident and ordinarily resident. I take up an appointment in Pretoria. A month later I resign and I repeat the process in Bloemfontein, Cape Town, Verkeersdevlei, etc. I was resident in Pretoria since I worked there for 2 months, but I was not ordinarily resident there. Moreover, if I have been so much on the move that it is impossible to determine where I have been ordinarily resident, my estate should be declared insolvent where I am resident on the date of the petition, or on another ground, but not on this ground. See Mars, page 19, and the cases cited by him. See especially Ex parte Exteam, 1938, WLD 223, for the meaning of ordinarily resident. 5. The meaning of property. No distinction is made between immovable and movable property. I have a claim, property, against A in Pretoria for the delivery of a motor car, a cow, etc. I am entitled to property in Pretoria, and my creditors may institute insolvency proceedings against me there. 6. At any time within the preceding year. A was ordinarily resident in Pretoria during 1946. During November 1946, he went to England. His estate may be declared insolvent on the 31st of December 1946 by the Transvaal Provincial Division. 7. More than one court. From the above, it is quite clear that more than one division may be able to declare a person insolvent. This is the reason why Section 149(1) contains a proviso in regard thereto. Read the proviso very carefully. C. Estates which cannot be declared insolvent. This question is not of much importance. For example, the relevant provisions treat of estates of persons on active service, which in terms of the Moratorium Act cannot be declared insolvent. A company must be liquidated, etc. See Mars, page 25. D. Deceased estates. The estate of the deceased persons may also be placed under sequestration. The sequestration itself is carried out in the same manner as an ordinary insolvent estate. The Administration of Estates Act No. 24 of 1913 prescribes the procedure to be followed in the sequestration of an insolvent deceased estate. See also Mars, page 26. E. The estates of married women. The estate of a married woman may also be declared insolvent. If she is married out of community of property, with exclusion of the marital power, she does not require the assistance of her husband in insolvency proceedings. If the marital power has been excluded, she does require such assistance. That is, the husband as well as the wife must be cited as respondents in the petition for sequestration. But what is the position if the woman is married in community of property? The general rule is there is only one joint estate. The husband is controller of such estate, and his estate, that is the joint estate, must be declared insolvent. A woman married in community of property has no separate estate which may be declared insolvent. This rule is, however, subject to a few exceptions. 1. In special circumstances, the court may perhaps accept the voluntary surrender, see later discussion, or grant a sequestration order in respect of the estate of a woman married in community of property. For example, if the whereabouts of her husband is unknown. Ex parte Powell, 1931, WLD 161, Mars, page 30. 2. Public trader. If a woman who is a public trader has acquired a separate estate, a voluntary surrender or sequestration of such estate is possible. Refer to the 4th edition of Mars. A woman is regarded as a public trader if she carries on a public trade or business with the consent of her husband, openly in the sight of all. In a succeeding note we shall discuss the voluntary surrender of estates. Group B, Note 3. The law of insolvency and how a person acquires an insolvent status. A. Officers in insolvency proceedings. Before dealing with a voluntary surrender, we must briefly discuss a few other questions. We shall first mention something about the most important officers in insolvency proceedings. A. The Master of the Supreme Court. The Master is the head of the office charged with the administration of estates, deceased estates, the estates of minors, and insolvent estates. The Master must also appoint sworn appraisers and exercise various other duties of a general nature which do not relate specifically to this course. There are Master's officers at the seats of all provincial and local divisions, for example Cape Town, Pretoria, Kimberley, etc. The Master has to perform a considerable number of duties in respect of insolvent estates. He must, for example, supervise the work of the trustee. He has to confirm the trustee's accounts, etc. In the course of our further studies, the compass of these duties will become apparent. B. The trustee. The duties of this officer will also be treated of in subsequent notes. B. Definitions. Section 2 of the Act defines a large number of terms. Students are in possession of the Act, and they should, therefore, study Section 2 very carefully. In the course of our notes, we shall give a full explanation of some of these definitions, for example, free residue, disposition, etc. But at this stage, students should become conversant with the above-mentioned section as it appears in the Act. C. Voluntary surrender of estate. A. What students should read. Mars devotes a separate chapter to this question, while sections 3 to 7 contain provisions relating thereto. Students must, therefore, study the relevant chapter in Mars as well as the sections mentioned. Students will appreciate that it is unnecessary to quote the contents of the Act in our notes, since they are in possession of a copy of the Insolvency Act. Our aim should rather be to give guidance to our students as to how to set about their studies, to point out which matters require special attention, and to supplement and explain such matters. It is therefore clear that students should not rely only on our notes. They should also master the Act. B. Voluntary surrender and sequestration. To sequestrate a person's estate means to declare the estate insolvent, in order that it may be administered by a trustee. There are two ways of sequestrating an estate. 1. The debtor himself may request the court to sequestrate his estate, voluntary surrender. Or 2. One or more of his creditors may do so, compulsory surrender. C. Who may apply for a surrender of estate. Study section 3 and pay special attention to the following. 1. Jurisdiction. The court may accept a voluntary surrender only if it has the necessary jurisdiction. See previous notes. My request cannot confer on a court jurisdiction which it does not legally possess. Only persons who are subject to the jurisdiction of a particular court may, therefore, apply to that court for the sequestration of their estates. 2. Partnerships. Note that all partners resident in the Union may sign the petition Ex parte Besta 1936 CPD. Moreover, they must also apply for the acceptance of the surrender of their own private estates. Mars devotes a separate chapter to partnerships in insolvency. Consult the 4th edition. The court will not accept the surrender of the estate of a partnership unless petitions have been presented for the surrender of the estates of the partners. Such private estates will be simultaneously sequestrated. See section 13. 3. Insolvent debtors. Pay attention to the persons whose estates may be sequestrated. For example, married women, see previous notes. Only persons whose estates may be sequestrated, or their agents, may sign the petition. D. Various steps to be taken by a person who wishes to surrender his estate. 1. Publication of notice of intention to surrender estate. Section 4(1). The wording of the Act is rather misleading. It is not a notice of surrender which is published, but a notice of intention to apply for the surrender of the estate. The court